King of Hawes, London Borough of Tower of Hamlets.
Yes, Mr. Wolfe.
Morning, my lords. As you will have seen, Mr. Jack Parker and I appear on behalf of the appellant. Ms. Daisy Noble and Mr. Syra Kabir Sheikh appear on behalf of the defendant. Ms. Antonia Glenda and Charlotte Kilroy appear on behalf of the interested party. The court should, I hope, have a core bundle, a supplementary bundle, a supplementary hearing bundle, as it's called, which is part legal materials and part contemporary documents, and a legal materials bundle.
Yes, Mr. Wolfe, I have a supplemental appeal bundle in 2 volumes.
That may be.
And we have a bundle of authorities.
Indeed. You will have seen, my lords, that this is an appeal pursuant to partial permission granted by Lady Justice Asplin in relation to an order for reasons given in a judgment by Mr. Justice Fordham December of last year, challenging a decision by the Mayor of Tower Hamlets in relation to what's called a low traffic neighbourhood scheme in that area. My lords, in terms of the way we're dealing with the hearing, I am going to deal with ground 3, which is effectively the consultation ground.
Yes.
Mr. Parker is going to deal with the LIP ground in that order. You've had a timetable from us. You asked for us to fit within 1 day, and we've done our best to do that. It will be tight, and the result of that is that I'm going to take our skeleton, if I may, as read,
yes.
And I'm going to formally adopt our skeleton.
Yes.
And I'm certainly going to take you only to the core materials that I think you need to see for the purpose of our appeal.
Thank you, and we're very grateful to all counsel for that agreed timetable.
My Lord, if I can start, if I may, with Miss Justice Fordham's judgment, just as a signpost to where we're going. You have that in bundle, the core bundle, tab 4, starting at page 22. In paragraph 2 of the judgment, the judge helpfully identified the statutory schemes that are in play. They are relevant to the LIP ground, and so Mr. Parker will deal with those. You have the materials in tabs 1, 2 and 3 of your legal materials bundle. In paragraph 3, the judge helpfully identified the statutory duties in play. Given where things now are in this appeal, can I just identify for you that within paragraph 3 of the judgment, we are within item number 4, which is about halfway down that paragraph, which starts the defendant has an LIP implementation duty. So we are concerned with 3 sub 4, and further down that paragraph, 3 sub 5b. Those are the elements in play in a statutory duties context.
Right.
And then in the common law duties, which the judge identified in paragraph 4, in terms of what remains live in the appeal, it's 4 sub 2, so line 3, the duty to conduct a fair and legally adequate consultation. That is where the case sits. My Lords, the decision identified by the judge in paragraph 5 is manifested in 2 documents, and I'm going to ask the court just to look briefly at those 2 documents. One is the minutes of the cabinet meeting, and the second is a public statement. I wonder if we can just pick those up, please, in the core bundle at tabs 19 and 20. At tab 19, within that, if you would please, that's the minutes of the meeting of the cabinet, but for slightly complicated reasons of local government, although this is a cabinet meeting, the decision is actually in the end a decision just for the mayor. And we see the minutes of the relevant decision at page 269 in your bundle, headed 6.4 Liverpool Streets, Bethnal Green Consultation Outcome and Measures.
Yes.
And within that, paragraphs essentially taken, as you'll see in due course from the officer's report. The decision is number 2, towards the foot of page 269, to approve option 1, brackets, of the 3 options summarised in section 2, subject to the retention of the closure of Can Robert Street in Bethnal Green. So immediately identifying that this was one of 3 options before the mayor, and within that, and I'll come to the relevance of this in due course, adopting one of the options, the closure option, but with an exception, that being the Can Robert Street exception. So in the end, not the mayor simply saying I'm going to do A or B, but doing a slight variation of one of them. And then the reasons section on the face of page 270, paragraph under the heading reasons for the decision says this: the options set out in this report, that's taken from the report, seek to address several issues that have been identified by residents and key stakeholders since the implementation of the Liverpool Street scheme in Bethnal Green. And that, once you see the context, is a reference to the evolution of option 3, because that's what is being described there. You then have, slightly below that, again taken directly from the report, under alternative options, the second paragraph there says this: the report sets out this third option in detail, along with the options to completely retain or remove the existing scheme. And our consultation ground is concerned with the way in which the council dealt with that third option, as you've seen. You then have at page 276 a statement published in this form, but also, as you will have seen from the judgment, read out in essentially this form at the time. And I just want to identify a couple of facets of this, if I may. But first of all, repeated through this is the Mayor's observation that this is uses the same word in slightly different ways, a divisive issue, the implementation or removal of the low traffic neighbourhood scheme. Second paragraph, he says it's divided our community. And then paragraph 4, second part of paragraph 4, a one-size-fits-all approach to improving air quality with limited consultation, etc., was always likely to cause disunity among residents in our borough. So he's identifying, it's an echo back to the process which have got us here, which is that this was implemented, if you like, as a binary scheme. And he's recognising both the divisiveness of the proposition. You'll see how responses were more or less 50-50, slightly in favour of retaining the scheme, but also the way in which that's caused difficulty in the community. Further down, he identifies divided views, emergency services. That's the fourth from the last paragraph. And then he says this, by the lower hole punch, if you have hole punches, our consultation shows division among residents too. Whilst there is support for retaining the schemes, roughly 42% of residents want them removed. So a majority want them kept, slightly less than a majority want them to remain. He is, as you will have seen, going with the option that has lower support. This is not a referendum, of course it's not a referendum, but what I would observe to the court is that he is nonetheless cognizant of the question of support, levels of support for things. That's a factor which is weighing in his mind. And he repeats that point in the next paragraph. For resident-owned results, margins are in the low hundreds. He is interested in the extent of public opinion. And then over the page, similar echoes, division, etc. And he, in the bullet points, then identifies the point that I've described already, that one of the, as it were, modifications to the proposals is we will also retain the road closure on Can Robert Street in Bethnal Green. So that's the decision as described. In terms of the history, what got us to that point, if I can ask you to go back to the judgment, please, starting at paragraph 15. I'm not going to take you through all of the detail, but just to position this within the judgment. The background to this, to some extent, matters which will be covered by Mr. Parker in the LIP process, is set out in paragraph 15. 16 and 17 all cover that same territory. Paragraph 18 explains how, in effect, having implemented the scheme, there was then an election at which a new Mayor of Tower Hamlets, as opposed to Mayor of London, was elected. And you see that the judge has included within that an extract from the manifesto of that mayor, who clearly won that election, which describes his intention to consider the Liverpool Street scheme, as he there calls it, but interestingly, for a political manifesto, actually sets out the law on consultation. So he goes to the electorate saying, I'm going to do this, but I believe in consultation, and he specifically refers to the gunning principles within his political manifesto. We then have paragraph 19 explaining what you're going to come to in a second, which is that there were then two phases of consultation, one in 2022 and one in 2023. I won't take you to the detail of the first one. You have in the body of the materials, if you like, the outcome results of that. It was a much simpler consultation on essentially the same proposals, retain or remove, and in that case, as in the later case, a majority of people wanted to retain the schemes. Nonetheless, there was a second consultation, and that's the one with which we are concerned. For the purpose of that second consultation, I wonder if you could turn, please, to tab 15 in the supplementary bundle. This is In terms of the document within which you're finding this is the appendix to the officer report to the cabinet meeting. Right now, slightly odd place. You'll see two sets of page numbers. I'm concerned with where the documents are printed sideways with the SB numbers at each stage. And within the appendices to the officer document, you have at SB 559 the first of two consultation documents. So these were the materials distributed locally and so on for local and wider residents to make comment on the proposals. Because the scheme in question, as you will have seen, covered two wards, Old Bethnal Green and Weavers, there are two documents, but for my purposes they essentially track the same ground. So 559, I'm just going to look at the Bethnal Green document for a moment. Within that at 560, Mayor's forward, second paragraph, second column, second paragraph. I'm pleased to present this document, which is the next stage in our consultation on proposals to address matters that have been raised regarding the Liverpool Street scheme, etc. And then right-hand column heading this consultation, we are consulting on whether to implement a series of changes that have been developed following engagement with key stakeholders and data analysis. So making clear that this has come out of a process from a previous consultation. The history, to some extent, of the scheme and a description of the scheme as it's been implemented is set out in paragraph on page 561 under introduction, and you have there, probably not very well reproduced in this document, a map showing the key elements of the scheme. And then at page 562, the heading is the options. Within that second paragraph, first paragraph, the council undertaking an evaluation, and then second paragraph below, we set out options which have been developed for respondents to consider. Option 1 sets out, and then option 2 sets out. So, as I say, this has come from a prior process. This is not coming out of the blue. This is the developed options. And then two options are identified. Option 1, remove the livable streets closures and implement a series of area-wide improvements to the public realm to encourage active travel. Option 2, retain the current scheme. So those are the two options that are being offered, and you'll see in a few minutes the document which invited members of the public to respond to this process, with those two options being offered. The document then in the second column says other options considered, and it explains, it identifies, mentions, I should say, two other options which were considered, or two other approaches which were considered and have effectively been ruled out. The first of which is a completion of the existing scheme which hadn't quite been completed. That's not critical for the purposes here. And then the third column, replacing physical closures with cameras. And what's made clear is that that's not on the table, and you'll see that further in the materials in a few moments. So two options being offered. Page 563 is the first of several pages which explain option 1. So option 1 is essentially removal, but with some bit of tweaking to that extent, which is why there are several pages describing it. So there are several pages describing option 1. I don't go through the detail of that, but essentially it is removal of the scheme that was put in a couple of years previously. And then you have option 2, which, because it's essentially the status quo, is described in shorter terms on page 567. Within this same document, you then have at page 575, part 3, guide to responding to this consultation. And it tells you can do that by paper or online, and you'll see in a moment, I'll take you to the document which allowed for that to happen. And then just completing a point that I mentioned previously, in the appendix which you have on page 577, how you responded to the first stage consultation. And if you look in the right-hand half of that page, there are blocks with bar charts for each of the component bits of the scheme, and in each case there's a slight majority, it varies from element to element, for retaining the scheme. So that was the outcome of the first consultation process, and we've gone to the second stage consultation process against that backdrop. You then have, but I don't take you through the detail of it, at 267, sorry, not 267, 579, the equivalent document for the Weavers ward area of the overall scheme. Very similar terms, certainly from my purposes, the same structure and has the same components to it. At tab 10, if I could then ask you to go to tab 10, you have the survey document available on paper or online.
So is this supplementary bundle?
Supplementary bundle, yes.
Tab 10.
Yes.
Yeah, that's in the other volume.
Apologies.
Just have to get that. Changes
Page
survey.
4, I'm sorry.
Changes survey.
Exactly right.
Right, got it.
Page 419. So this is, if you'd followed the instruction at the back of the consultation document, this is the document you would have got to give your answer. And what you see, there's various bits of information, and I'm not so focused on these bits of information asking about who you are and where you live. The where you live is peripherally relevant, because what you'll see in due course is that the statistics are broken down by people who live within the area and people who don't live within the area. But then there's a range of other information sorts around who you are, demographic information and so on, which is obviously relevant to the council's consideration of these things. But halfway, 2/3 of the way down, page 419, in bold, the council is presenting two options, and then it gives the respondent the option of supporting option 1 to remove, or supporting option 2 to retain. So it's a binary option. Within that, there is a little bit of refinement. If you go over to page 420, to what extent do you agree or disagree with the proposed changes set out in option 1? So within the removal option, just as we'd seen a little grid of squares in the first round consultation, breaking it down into components, there is the option to say I agree or disagree with elements of the removal, but not the whole of it. So there are refinements within option 1, but there is no refinement in option 2, because option 2 is simply retention. And our overall simple point is that there's no option 3. In terms of the evaluations, a whole load of questions that you can express views on your feelings about the existing scheme. The closest this gets to any open question of relevance here is on page 423, which at the top of the page says this: please use the space below for any comments you wish to make on the options. Please attach additional pages if you wish to. So that's directing to comments on the options. Nothing in there, we say, would give the reader any sense or any suggestion that there might be other options available, which were simply neither option 1 nor option 2, but a completely third option.
Would you accept that a possible answer to the question asked on that page was none of the above, just as in other contexts, respondents to surveys might say none of the above, please go for something different?
Yes, you can always write that on the piece of paper, absolutely, but in our submission, and I'll show you authority to this effect, that's not an answer to the proposition that you needed to explain the proposal if there was one.
Well, that's a different question.
Understand
but respondents to the survey could have said, we don't agree with either option 1, option 2, we want the following.
Absolutely, they could have done that, yes. In the period leading up to the decision in September, you will have seen, I don't take you to the detail of it unless I need to at the moment, the judge mentions at paragraph 56 of the judgment, he refers to a meeting which took place in May. You have a slightly convoluted email trail which deals with this, in which the group, not a group which all speaks with one voice, but all working together, the group with which the claimants associated had a meeting with one of the council's officers, and they were told, and the judge records this in paragraph 56 of his judgment, that the defendant was not working on any option 3. That's the way the judge records it in the judgment, and you've got the documents underlying it. So at the point where they met with Mr. Chibu, the council officer, they specifically discussed that question and were told in no uncertain terms the council was not working on an option 3. So while somebody could have written in and said none of the above, there was no sense that there was an option coming from the council that one could say, well, actually, I quite like your emerging third way. The officer's report, which you then have in tab 15, you've already seen some of the appendices to this.
I have it in tab 40.
Oh, sorry, you're absolutely right, tab 14. 14, 15 is the appendices.
Yeah.
First of all, if I may go to the back of that document. Yes, sir. Apologies. If I can just perhaps go to the appendices, it's the easiest way to start. Page 500, which is in the appendices, just to get the headline response figures out of the way. It's SB 500. You have Appendix B and then 523 on Appendix C. This gives you in a table on the middle of SB 500 the overall support and rejection figures for two different things. One is people who live within the affected area, and one is the totality of respondents, because people responded from outside the area. And you see, just to pick up those two distinct situations, the left-hand box, halfway down page 500, supportive options, all valid responses. It's roughly 77% in favour of retention of the scheme, 23% against. And then all valid responses from the consultation area is the right-hand box, and it's 58.3% in favour of retention, 41.7% in favour of removal. Similar breakdown, if you want to see it, in the Weavers, which is Appendix C at page 523. The Mayor, this is not a criticism, it's just an observation, the Mayor then focuses on the residents' responses, but even, as I say, within the residents' responses, you get this slight majority in favour of retention, and that's the context in which the Mayor describes this as divisive. So then to the officer's report, sorry for the diversion, tab 14, starts at page 464, and then 465 under recommendations. What you see is that the text on 465, including below, further down the page, the headings, reasons for decisions and alternative options, it's that text which, with obvious necessary tweaks, ended up in the minutes of the meeting reflecting the process, and that's why the minutes, as you saw, referred to this report, and this is where you see that text has come from. And so the recommendations, number one, receive and conscientiously consider the results of the engagement, and then number two, to approve one of the three options summarised in section 2 of this report. And what you'll see is that whilst the officers drafting this report identify pros and cons of the schemes and identify option 3 as being on balance preferable, they don't actually make a recommendation as between the three schemes at any point. They offer that up to the Mayor. You then have, starting at 466, a description of the specifics of option 1. Obviously that needs to be detailed because it's a fairly complicated package. And then over the page 467, option 2, simply retention, that's simply described. And then option 3, which again, because it's a slightly complicated package, requires some description. And there's a description of the various elements, which are a hybrid of the other two schemes to some extent, but also introducing additional elements that were not there before. That's 467. 470. So take the following pages, there's a series of references to responses from, for example, emergency services. Emergency services express concerns about road closures and therefore their ease of access within the streets. On the other hand, you go to page 471, and the secondary school and the public health team are very in favour of the public health pedestrian safety benefits of keeping traffic-free roads and so on. So those are the two broad themes of the positions taken by members of the public and the statutory agencies. That is then summarised, 473, the heading 3.3.2, themes from residents supporting option 1 included, themes from residents supporting option 2 included, that's all set out in detail. 334 gives you a summary of the figures you've seen in a bit more detail as to how the responses were split. That then takes the officers to page 480, takes the court to page 480, and there are several pages, and we say that's notable, in which the officers describe in some detail the basis for developing an option 3, and they set out sub-area by sub-area what they have suggested and why, specifically, and I don't take you through the detail of this unless I need to, in order to try and address some of the concerns, for example, identified by emergency services. And that's what they say. Option 3 seeks to take a balanced approach to address responses received in the consultation, consideration of the data, and the development of the equality impact assessment as set out in section 4 of this report. So it's not a response to any one element, it's a response to a range of things, seeking to balance and find a hybrid that, in the officer's views, is capable of meeting not necessarily everybody's, but more people's wishes and needs. That's from 358 following. They specifically at 391, page 485, answer the question, or pose and then answer the question, how option 3 will address concerns raised through this consultation. And they go through that in specific detail, giving their comments on those various things, theme by theme. And then at 392, they evaluate the options, leading to a summary at 394, in which they say, option 1 scores strongest in terms of access to emergency services, option 2 scores highest in terms of road safety, air quality and public realm, and option 3 scores highest overall by striking a balance between competing demands in the streets and scheme area. It seeks to address most of the concerns of stakeholders that support options 1 and those that support options 2. Not claiming to completely meet everybody's needs, but claiming to meet most of them. There is then, just for completeness, at page 489, under the heading Comments of Chief Finance Officer, 6.2 tells us that the implementation of option 1, this is the cost of removing the stuff that was previously put in at the cost of about £2 million, it's 2.5 million removed. Option 3 is 1.2 million, and obviously option 2, leaving it in place, has effectively no cost at all. So that's the context, and that then feeds into, informs the Mayor's decision. So faced with 3 options, as it now is, the Mayor decides that this is decisive, but my answer to it being decisive is to opt for one of the 2 binary options, and not opt for what's identified as the hybrid option, or I'm calling the hybrid option, but nor to know what the public would think about the hybrid option. And that's the kicking off point for our concern about the approach that was taken here. Not the not adopting option 3, but the not consulting on option 3 once it had been identified within that internal process. But also in terms of the law and the legal background for all of that, if I can ask you to turn to the judgment again. Okay. Within the judgment at page 47 of your bundle, paragraph 58, picking up our summary of our submissions, but flows into paragraph 59, and I just want to pull your attention, if I may, the judge having set out the submissions which he doesn't accept, towards the end of paragraph 59, he makes the point that the case law, some of which I'm going to show you again in a moment, the case law, on the situation where there are third options emerging, the case law is all concerned with the situation in which the third option is adopted without there having been consultation. We're clearly the situation in which the third option was not adopted. And at the top of page 48, the judge makes that point. He says, in the present case, option 3 was not adopted. Ms. Sheikh Casey agreed there could, in principle, be an unfair failure of reconsultation where the unfairness relates to a new suggested but rejected new course. I agree. And we say that's the correct starting point. It may be that none of the cases actually deal with this specific situation. They're all dealing with almost not necessarily the mirror situation, but the different situation. But it's not being suggested there, and I don't think it's been suggested in the case since, that in principle, fairness could require consultation on a third option that's emerged, which is then not adopted. And in my submission, just to pick the point up initially, the issue is at the point of presenting the third option. It's not dependent upon whether that third option is then actually the one chosen or not. It's the emergence and identification of the third option which triggers the consultation fairness obligation, if at all. So we then say, just again to introduce the point in general terms, once accepted that fairness can in principle require a third option which has been identified in the process to be consulted upon, once crossed that line, we say this case is a clear example of where that's the case. It's been emerged, come through a process which has identified two polar positions. It's been identified as being divisive. The population is broadly split, not 55-45, whatever it may be, in terms of those options. The option is then identified very specifically by the officials out of the blue in order to address that concern. We say that's a paradigm case. Hard to imagine a case clearer where the obligation to consult on that third option would not arise. In terms of the case law that we say sits behind that, can I ask you to look, Mosley, the case that continues to give and give, does actually speak to this question. We say, Mosley, you have in your legal materials bundle at tab 14. This, of course, was the point at which the Supreme Court pulls together many years and many cases worth of jurisprudence on consultation. I want to take you first to Lord Wilson's judgment and then to Lord Reed's judgment. Lord Wilson, in paragraph 23, sets out the law, and as I'm sure the court knows, this is the point at which the court ultimately adopts the sometimes called Gunning criteria, the ones that the mayor here actually mentioned in his manifesto. And we get two slightly different analyses here, and I want to show you both of them, one from Lord Wilson and one from Lord Reed. The starting proposition, certainly for Lord Wilson, is that what underpins the law on consultation, however it's been generated, is the common law duty of procedural fairness. But I want to look slightly closely at what he then says in paragraphs 24 and 25. 24, fairness is a protean concept, not susceptible of much generalised enlargement, but its requirement in this context must be linked to the purpose of consultation. In Osborne, the court addressed the common law duty of procedural fairness in the determination of a person's legal rights. Nevertheless, the first of the two purposes of procedural fairness in that somewhat different context, identified by Lord Reed in paragraph 67-68 of his judgment, we'll come to that in a moment, equally underlie the requirement that a consultation should be fair. First, the requirement is, quote, liable to result in better decisions by ensuring that the decision maker receives all relevant information that is properly tested. So just pausing for a second there, that is, I'm going to call it, it's a public interest component of fairness. Different to the prison, Mr. Osborne was a prisoner, different to the individual element of fairness. This is a public interest component of fairness. Better decisions by ensuring the decision maker receives all relevant information that is properly tested. And we say here, absolutely right, better testing of the information by ensuring that the mayor, in the context of looking at this divided situation, would receive views on what his officials had identified as a potential middle course. Second, it avoids the sense of injustice which the person who is the subject of the decision would otherwise feel. That is a subjective question. Such are the two valuable practical consequences of fair consultation, but underlying it is also a third purpose, reflective of the democratic principle at the heart of our society. The third purpose is particularly relevant in a case like the present, in which the question was not yes or no, should we close this particular care home, this particular school, etc. It was, required as we are to make a taxation-related scheme for application to all the inhabitants of your borough, should we make the one on the terms which we here propose? And we will also in that.
What is the third purpose, and how does it differ from the first two?
Well,
because to my reading of this paragraph, he doesn't actually spell out what the third purpose is.
He doesn't, but I think my observation inference from the way he describes the two situations is that in the third situation, and this is all in the context of a case which is about the potential need to canvass alternatives. So if you literally are in a situation where there are only two choices, open or close the school, open or close the care home, alternatives is less of a relevant question. In a situation where you're doing something more nuanced, which is the example he identifies there, was the facts of Mosley, which was about a taxation scheme and so on, where there may be more scope for variation, the purpose, by implication, we would say, is to illuminate the potential detail of that variability. And we say that that's why, in the context of an argument, as this case was about providing alternatives, And in the context of the present case, which is about providing alternatives, we say part of the purpose is to explore the alternatives. That's a slightly long answer to my Lord's question. Where there are potential alternatives, part of the purpose is to explore the alternatives. We then have in paragraph 25, this is where Lord Wilson sets out the gunning, the proposition quotes from that, and also picks up in the second part of 25, below letter G, the Court of Appeal decision in Coughlin. So the gunning gives us the four headline points, the four stages of the process, which we're concerned. Coughlin illuminates part of that in the quote at the foot of the page. It says this: it has to be remembered that consultation is not litigation. The consulting authority is not required to publicise every submission it receives, absent some statutory obligation to disclose all its advice. Its obligation is to let those who have potential interest in the subject matter know in clear terms what the proposal is and exactly why it's under positive consideration, telling them enough, which may be a good deal, to enable them to make an intelligent response. And we say, just applying that phraseology, that concept to the situation we're in here, once we get to the meeting, the proposals that are under positive consideration now include option 3. This is not simply and there's another thing that somebody might have suggested, it's not simply that residents have said, none of the above, what about doing this? This is a positive option which has come from officers, which has been written up in a detailed and professional way to present to the mayor. And so we say, when you look at that, here we have an option under positive consideration, which we say needed to have been presented to people for their
Mr. Wolfe, can I ask you this? Suppose there were that further consultation and lots of interesting new ideas come forward, either directly from the public or the officers think, well, actually, having considered these new responses, we think that option 4 should be considered by the mayor.
Well,
would your logic mean that you then have to have another round of consultation on option 4?
No, because this is all, as we see, and I'm hoping I'm explaining, looked at through the prism of fairness. Each case is on its circumstance, I don't say on its facts, on its circumstances. So the question would have to be asked then. But it would always be thus. Any fairness question about a consultation process is always going to say, at any stage, what does fairness require at this stage? And what I'd say in answer to the question, my lord, is there's absolutely nothing mechanical that says if an option 4 came forward at the next stage, it would need to be consulted upon. It would depend upon the nature and extent of option 4, it would depend on how option 4 emerged, it would depend whether option 4 would literally come out of people's responses, which it might do, in the way that the Can Robert Street option came out of people's responses and so on. So we are looking at the very specific circumstances that prevailed at this point in time, and on that basis we say that fairness required this proposal to be consulted upon. All bets are off in relation to what might happen down the line, and we're not seeking to set some. I mean, consultation law is riddled with individual cases. We're not seeking to set some framework that says here is a prescription for when further consultation needs to arise.
Could I just ask this? One way of looking at option 3 on the documents you showed us is that, this is putting it very broadly, what happened is there was consultation, various stakeholders raised concerns, and the officers then sought to come up with a way of meeting the concerns that had arisen in the consultation, and that then is what they branded option 3. But one way of looking at it is that they were putting forward another possibility deriving from the consultation process.
Well, I don't know. Well, I think
in part at least.
Yes, I think if I'm understanding my Lord's proposition correctly, it obviously followed chronologically. They had before them the consultation responses. Those consultation responses included, for example, emergency services who said, look, we want to be able to drive our vehicles without any delays or whatever it may be. So to that extent, they were taking those things into account. But I don't think that means it was derived from them. It's not designed on the basis of what consultees said. It's saying, well, look, we have these two, not competing, but needing to be reconciled imperatives, and we're going to try and reconcile them. But also, to pick up the point about where it's derived from, it's not irrelevant that this is the second stage of the process. There was a consultation in 2022, exactly the same points would have been made then, that they're not new points, they are about, they're almost points of principle. So when the council goes through a 2022 exercise and then says for 2023, this is developed in the light of what we've done before, it really is emerging late in the day when we get option 3 in the committee report a few days before the committee. Just to press on with Mosley, if I may, paragraph 27. Paragraph 27. Sometimes, particularly when statute does not limit the subject of the requisite consultation to preferred options, fairness will require that interested persons be consulted not only on the preferred option, but also upon arguable yet discarded alternative options. And there's some case law there. We're essentially in that situation because the mayor had expressed a preference. You've seen that in his election materials. Officers presented the 3 options without a recommendation, as you've seen. This wasn't yet a discarded option. It was now an option on the table. All the more so, we say, therefore, that it needed to be part of the picture that consultees saw. I said I would also take you, if I may, to Lord Reid, paragraph 39. He takes a slightly different approach to the fairness kicking off point, but I don't need to dwell on that. Paragraph 39, he then says this: in order for the consultation to achieve that objective, it must fulfil certain minimum requirements. Meaningful public participation in this particular decision-making process, in a context with which the general public cannot be expected to be familiar, requires that consultees should be provided not only with information about the draft scheme, but also an outline of the realistic alternatives. So again, this is not discarded options. This is realistic alternatives. So we're not simply in the territory of discarded options, and we're not simply in the territory of a scheme which is picked out having been identified through the process. We're in the territory of realistic options. And absolutely, option 3 is presented by officers in good faith as being a realistic option. Also, I just want to look briefly at 2 other cases, if I may. Well, one is a case called Montpellier, which is in tab 12 of this bundle.
Lord Reid didn't deal with it as a matter of fairness, did he?
No.
So is your argument advanced on the basis of fairness or some other principle?
That is the majority view.
Yeah.
That's the majority position. Most of the cases that you can kind of unpick in different ways. It's the majority position, and what I say is that whether you look at it through the prism of fairness, see Lord Wilson, or in a slightly different way, as Lord Reid is more interested in the statutory context than pure fairness. All I say is that he gets to what we say is the equivalent result by a slightly different route.
I don't know if it's of any relevance, but at paragraph 44, 2 members of the court express agreement with both judgments.
Exactly.
Well, you say exactly. I'm afraid sometimes that leaves us uncertain what the ratio is.
Well, I agree, and I, for my purposes, I simply say that both Lord Reid and Lord Wilson are on the point that matters for me, speaking with one voice.
I see.
Montpellier is in tab 12 of your bundle. And I just want to pick up a point that it slightly arises from the question that was put to me earlier on, which is what you make of the form question. And this too is a road closures case. Paragraph 29, if you would, on page 195.
Yes.
Sorry, in the time available, I've dived in slightly necessarily. I agree on this point with Ms. Carrington. Fairness, in my judgment, required that there should be a process of consultation in which those being consulted could express their views on all the various options. this never took place. It's no good, Mr. Cosgrove, saying, even if it is the case, that proponents of the retention of the barriers express views supportive of that contention in the course of both the statutory process and subsequent consultation exercise. Fairness required a consultation process in which all those interested, whether pro or con, were invited to express their views on all the various options. That's the writing. It's not enough that you could just say none of the above. That doesn't answer the failure to give you the proposals. And again, not sort of overly construing Mr. Justice Mumby's judgment, but on all the various options, we say that's the position here. One more, if I may. Keep Wythenshawe special, Mr. Justice Dove, as he was, tab 16 of your bundle. It's a helpful place to pull together a couple of other authorities. Page 304, para 73. This is looking at the point in a slightly different way, which is that it's dealing with a situation of where a new proposal emerges, again, ultimately because of the way the case law is developed, which is then adopted, but the extent to which the change triggers potential requirement of further consultation. Starts at paragraph 73 in Mr. Justice Dove's judgment, but he immediately picks up, and it's a helpful place, I would say, to get some of the case law from a case called Smith, Mr. Justice Silver, and then the paragraph numbered 43 at the top of 305 is from Smith, but it builds on, as you see further down the page, a divisional court case called Duffus or Duffus. So 43, as a matter of crucial importance in determining whether the defendants in this case should have reconsulted on the proposal under challenge, was the nature and extent of the difference between what was consulted on the consultation paper and the proposal accepted in March 2002 decision. So it was a case where what was accepted, agreed, was a new one rather than that being rejected. But here, and again you'll see Mr. Justice Dove using the same formulation, they look at nature and extent of the difference as a bit of a diversion into adopting a word of significance, which I think the courts then step away from because it's not a proxy test. But what one is looking at to some extent is the nature and extent of the difference. And we say nature of the difference is important here because within the rubric of nature, we say, look at the circumstances of the way this has come forward. It's not simply about saying, let's look, as I think the judge did, the granular difference between the two schemes and work out whether scheme 3, how far away it is from one of the other schemes, or option 3. It's also about the nature of it. The nature of it here is that it's put forward as something which potentially meets most people's needs, whether they're in favour or removal. That's about nature. It's put forward as a compromise hybrid which scores best in the officer's assessment and is put forward to the mayor for that purpose. Not simply about looking at the minute, comparing it with one traffic junction to another. It's about the situation which has got you into this position.
What do you say about what Mr. Justice Silver said in the last sentence of the quote, which is at the top of the following page? And as I understand it, represents his conclusion. This means that there should only be reconsultation if there's a fundamental difference between the proposals consulted on and those which the consulting party subsequently wishes to adopt. And then there's some discussion by Mr. Justice Dove of that phrase, fundamental difference, in the following paragraph.
Exactly. Yes, and as I say, Mr. Justice Dove, to some extent, not wishing to adopt a sort of substitute, a sort of proxy label that would give you a one-size-fits-all answer, and we do the same. We focus. This was a case where the focus was indeed on the granular difference between the proposals. We say in that case there is a significant difference between them, but also not the focus of Mr. Justice Silver's consideration, not the focus of Mr. Justice Dove's consideration, the nature of the difference. The nature of the difference. The nature of the difference here is the way in which this has come forward, why it's come forward, what the officers are seeking to offer the mayor as a third way. So it's not mopped up in that significant difference paraphrase. And then 75, Mr. Justice Dove himself, about 6 or so lines down the paragraph, then picks up, heavily influenced in this particular context by the nature and extent of the differences. He picks up the same language.
Mr. Wolf, can I just let you know that that clock is 2 minutes slow?
Thank you very much. I'm just hit my target, I think. So with that look at the case law, You have our skeleton argument, if I may. Within that, and I won't grind you through it, you have the materials. Paragraph 55, sorry, yes, paragraph 55 and 56. We identify a series of reasons why we say the judge was wrong. I don't repeat all of those. The simple overarching proposition is the way in which this arose through the divisiveness of the scheme, the way in which this was brought forward in the context of a mayor who clearly was concerned with extent of support, see Can Robert Street, and was seeking to find a way through that divisiveness. And that is a very specific situation that drives what we say is the requirement of fairness in this particular situation. In terms of the way the judge dealt with it, you have his paragraphs at paragraph 60 and 61 in particular.
Yes.
Just to pick up a small point on his 5 or so, six lines down, he says this: consultees, this is paragraph 60, had not been specifically asked about the removal of the scheme with the Can Robert Street closure retained. And I think the word specifically there is very heavily lent on by the judge, because as you saw, respondents could pick out elements, of which Can Robert Street was one of the elements in that response to consultation.
Yes.
Paragraph 60, though, the thrust of that, and why we say the judge gets it wrong, is about 3/4 of the way down the paragraph. He says, it was foreseeable that officers would do this.
Yes.
So in other words, the implication of that, and we say this is where the judge starts to go wrong, is that people should have seen the possibility that officers were going to present some third way, notwithstanding that the materials didn't give any hint of that, notwithstanding the fact this was a second consultation where only 2 options have been presented, notwithstanding a meeting between the claimant group and officers who said there is no third way on the table. Somehow people should
Well, I could see the force of that point if option 3 had been adopted, because then you would have been in a strong position to say, well, people had no idea that option 3 was under consideration, and therefore how could they comment on it? But does that argument have the same force when option 3 is not adopted?
In one sense, it has more force because what people have been deprived of is the opportunity to comment on something that was a foreseeable, to use that word, to use the various words used in the case law, option on the table, my paraphrase of the various cases I've taken you to. This was now an option on the table that hadn't been on the table before. And there's no way people could have known that was going to be on the table. There's no way people could have said, hang on a minute, in the responding to the form point, we're going to guess that you're going to do something exactly the opposite of what you've told us that you're doing, exactly the opposite of what the documents look like, and come up with a third way, which we're going to comment on in the not in the abstract, but in not knowing what it looks like. We're going to comment on a third way that we haven't seen because we think you might produce one. And we say that's what's packed into that analysis by the judge.
It may go slightly further than that. On your submission, I think you would say that ultimately what matters is whether the decision maker has been fully and properly informed. And if let's just say, for the sake of argument, I'm not speculating, I'm just hypothesizing to test the legal question. Suppose, for the sake of argument, there had been a further consultation which included option 3, and 90% of the residents said, we like option 3. Your submission, I think, would be, well, that was something that the mayor might well have wanted to take into account.
Well, absolutely, and that goes back, if you go back to Mosley, what I identify is the public interest element of fairness. There's some subjective elements, which is the individual consultee being deprived of something, but the very first one was, I think I'm playing back to my law what you've just said, which is that the fairness is there to support good decision making.
Yeah. Okay. Now I don't want to curtail submissions at all, but we do have the agreed timetable.
I've got one more point.
Yep. And obviously, I'll expect the appellant to take together the time that's been allotted to you. It's about how you divide it up.
Absolutely. I've got one more point in relation to paragraph 61.
Right.
Which is effectively in paragraph 61, what the judge is saying is that The claimant and people he was working with didn't, as it were, cry foul and say this needs to be consulted on at the time, to the extent that they did, and I say that they didn't say option 3 is a potential unifying option. Now we say whether they said it's a unifying option is neither here nor there. The point is they did say there needs to be consultation, so there's reference at the top of 61 to correspondence, in which the judge rightly pulls out the 2 key bits from the letter that was written to the council, having seen the officer's report, which is this proposal has been made without proper consultation. That's line 3. And line 5, not had sufficient work or consultation. So precisely the claimant group did say you need to consult on option 3. Lords, I finally just observe, first of all, there's a number of points in Severe Shake's submissions that are without a respondent's notice but new. I'll deal with them in reply if I need to. Finally, just observe there is no section 31(2)(a) argument here that says the result would highly likely be the same. Lords, unless I can assist further, I will hand over to Mr. Parker.
Yes, thank you. Mr. Parker, on the timetable, you have until 12:10, but do bear in mind that's 2 minutes slow.
Yeah, would you mind moving
I'll take your water before you spin it. Yeah.
and your bundle?
Got the other one?
No, my Lords, appeal grounds 1 and 2 relate to part 4 of the Greater London Authority Act 1999. In terms of the structure of my submissions, I'm going to address you briefly on the statutory framework, give you our case in a nutshell, and then turn to the judge's 3 reasons as to why, in relation to ground 1, he found there was not a breach of statutory duty. That will take the majority of my time, and then deal with ground 2. If I can start then with the statutory scheme and ask you to take up the authorities bundle at tab 2. Chapter 1 of part 4, as we are here concerned with, in my submission establishes a hierarchy of public authorities entrusted with the production and implementation of transport policy in London, and provides statutorily defined roles for each of those authorities in that hierarchy. And we see that played out in the provisions by section 141 subsection 1. It is for the Mayor of London to develop and implement transport policies for Greater London, and by section 142(1 for the London Mayor to publish a transport strategy containing those policies, and that transport strategy here is commonly referred to as the Mayor's Transport Strategy, or the MTS. By section 143, the London Mayor is subject to the oversight of the Secretary of State, so she sits above him in the hierarchy, and then below the London Mayor in the hierarchy are the London Borough Councils, such as the respondent. By section 144(1), those London boroughs must have regard to the MTS in exercising functions, so have regard duty. And then by section 145, they must prepare a local implementation plan, as it is called, a LIP, commonly referred to, containing the borough's proposals for the implementation of the MTS in its area. Then by section 145(3), we can see that the LIP must include a timetable for implementing the different proposals in the plan, and the date by which all the proposals in the plan will be implemented. That provision is obviously relatively important in this appeal, given the issues addressed by the judge. In preparing its own LIP, the council must, by section 144(3), if we go back one stage, also have regard to guidance produced by the London Mayor pursuant to section 144(2), and there was guidance produced by the Mayor in this case, and we'll come on and look at it. By section 146, the LIP, having been produced, must then be submitted to the London Mayor for approval, and we see at subsection 3 that the LIP must not be approved unless, in the Mayor's view, it is consistent with the MTS and, crucially here, adequate, and that the timetable for implementing the proposals in the LIP is adequate. So for the mayor to judge as to the adequacy of the timetable, there is then a power on the part of the mayor to prepare a plan, not relevant here. Section 148 and 149 gives rise to a power to prepare a revised LIP at any time. I'll touch on that tangentially. And then at section 151, the framework culminates in a duty imposed upon a council once the LIP has been approved to, at subsection 1A, implement the proposals in the LIP in accordance with the timetable included within it by virtue of the preceding subsection. Now, I'll come back to the specific parts of the statutory scheme in the course of my submissions, but that's the scheme in overview. A couple of brief comments. The Tower Hamlets mayor...
Just ask a quick question. Sorry, no, I think the answer is evident. So we've got... I don't know if actually it is worth asking the question. So A says in accordance with the timetable, and B says by the date. What's the difference?
Yeah. Well, if you go back to section 145.3a, where the story starts, the implementation plan must include both a timetable for implementing the different proposals in the plan and the date by which all the proposals in the plan will be implemented. It perhaps makes more sense if we look at that issue when we come on to look at the guidance that was produced by the mayor, which provides, as it were, the real-world application of these statutory provisions and how that is then reflected in the LIPs. But essentially they are two similar but ultimately different aspects of the timetable duty.
Right. So the timetable we would understand to be the stages on the way,
yeah,
and the date is completion.
Yes. Or completion of all of the proposals in the plan. So timetable encompasses timetable for individual proposals, and there may be interim steps, interim points in time at which individual proposals in the plan may need to be implemented in accordance with the timetable that's produced pursuant to section 145.3a. And then finally, long stop date for all the proposals in the plan, the point in time at which all the proposals in the plan need to have been implemented by.
Thank you.
Now, the respondent would like to cast the decision under challenge as a political small-peeped decision by a democratically elected mayor bringing to bear the manifesto on which he has been elected. And we say it's important to keep in mind that the Tower Hamlets mayor derives his powers from Parliament, we know that in constitutional terms, and in this context, we say he is empowered to play a relatively tightly constrained, statutorily defined role. Once the Tower Hamlets LIP has been produced pursuant to section 145 and approved by the mayor pursuant to section 146, it is the role, the duty of the Tower Hamlets mayor to implement the proposals in the LIP pursuant to section 151, nothing more, nothing less. That's point one. And secondly, we say, standing back from the intricacies of the legal arguments in this appeal, we say that the decision by the Tower Hamlets mayor to permanently remove, as it were, a centrepiece proposal in the council's LIP with no intention of reinstating it is obviously contrary to the MTS, and the effect of the decision to remove the scheme, we say, is to drive a coach and horses through the intended objective of this statutory framework, which is to ensure consistent delivery of the mayor's transport strategy across London in accordance with the mayor's strategic role in the production of transport strategy for London. So those are the comments on the statutory framework. I then turn to our case in a nutshell. It's set out in the skeleton argument, but the scheme about which we are concerned was included within the council's approved
I'm so
LIP.
sorry, Mr. Parker. Sorry, before we leave the legislation, can you just help me with this? As you've shown us, there are a number of places in the legislation where duties are imposed. And as you've said in answer to my lord, it's not just one duty. a completion date. There's actually duties, as I understand it, along the way, in accordance with the timetable. But suppose, I mean, it often happens, I'm afraid, in public life, that with the best will in the world, timetables are not adhered to. So what does the legislation contemplate can happen then? And who can enforce, if they are properly characterised as duties, whatever that may mean, who can enforce them? Is it the Mayor of London?
Well, my lord, we're obviously jumping ahead a number of stages because in my submission that essentially goes to remedy.
Oh, I see.
But, my lord, taking the points in turn, we say it is a statutory duty. It's framed in terms of a duty. If we look at the words of section 151, there is a requirement, shall implement the proposals. We say that is a statutory duty. It's plain on the face of the language. In terms of...
Sorry to interrupt, but I take it, I mean, I don't think this is in dispute. I think we need to be clear about this. There's no statutory remedy for breach. So in other words, what one doesn't see is a section 154, which says, and if the local authority doesn't comply, then the consequences shall be as follows.
No, my lord. I should say that at first instance, Mr. Justice Fordham was concerned with whether section 152 might provide an exclusive statutory remedy.
Yeah, well, that's one reason that lay behind my question.
Indeed, my lord, which is why Mr. Justice Fordham addressed it in the context of a remedy. Did this provide an alternative remedy? And so, as it were, it's logically the end of the process. If the court were, in a given case, was satisfied that there was a breach of statutory duty, what should the court do, if anything, about it? And is there another exclusive statutory remedy that the claimant should pursue?
You may be right. You may be right. No, we're just exploring the legal principle. One of the things that occurs to me is that this can often be a very delicate exercise. There are lots of factors that the democratically elected decision makers may want to have in mind. And the Mayor of London may not necessarily want to go to court because that could have certain implications for his city. He may want to engage in discussion with the democratically elected mayor of one of the boroughs and say, can we reach a compromise? How is the law supposed to address that if the so-called duties are in fact really duties owed to the Mayor of London and he chooses to approach them in a slightly different way? What should the law's approach be? See, the other part of my question, which is in my mind, is that it may be, although you've couched your argument in terms of duties, it may be that, as you said to us a moment ago, what you're really complaining about is an unlawful exercise of power, by which I mean that you say that the London Borough of Tower Hamlets has taken a decision which drives a coach and four through the Mayor of London's transport strategy, and that they've done it in a way which they're not empowered to do by the legislation, because there's a perfectly obvious way. If you don't like something, your submission is the legislation creates a scheme for you to put forward a revision, and that's the process that you should go through. So if I understood your submission correctly, that in essence what you're submitting is that the respondent has acted unlawfully by doing something which they don't have power to do.
Well, my lord, I don't want to be opportunistic. That's not, as it were, the front and centre way that we put our case. But at the same time, we do say that if the Mayor of Tower Hamlets had wanted to proceed in this way, there is an avenue that is open to him, which is, as my lord has posited, to prepare a revised lip, submit it to the Mayor and have that revised lip approved. And in a way, both points are mirrors of each other. But we do maintain the position that a decision to remove a scheme in breach of the implementation duty is unlawful for by reference to that breach.
You say it's a straightforward breach of duty, and when it comes to remedy, not only the Mayor of London, but anyone with standing can
Indeed.
ask the court to grant a mandatory order.
I do say that, indeed.
And do you go so far as to say that that can be done even if the Mayor of London opposes it?
Well, the court would need to, obviously the court retains the discretion as to whether to grant a remedy, even if it identifies that there is on the face of it a breach of duty. And obviously the court would want to have regard to anything that the Mayor of London might say, or TfL, as the interested party here, might say, about the appropriate thing for the court to do in that situation. But all of that goes to remedy. If I may just come back, because my Lord's question raised in my submission a number of different points in relation to the facets of this scheme. The first thing to say is, on the facts of this case, we are not concerned with questions about timetabling. Because on the facts of this case, there was a timetable in the local implementation plan. The uncontested evidence from the respondent, and I can take you to the respondent's witness statement, was that the scheme in question here was implemented in accordance with the timetable pursuant to the LIP duty. So on the facts of this case, we are dealing not with, was this scheme delivered 1 year after the timetable? Was there a slip in the timetable? Is there some nuanced negotiation that might be undertaken between the mayor? We're dealing with a scheme that was put in and is now being proposed to be permanently removed. So in my submission, the judge became unduly concerned with questions of timetable, because timetable doesn't arise at all on the facts of this case. In terms of the mayor's powers, yes, the mayor has the discretionary power to take action pursuant to section 152. I think, my Lord, I should say, as a matter of fairness, this point has not been contested by the respondent. We would probably want the opportunity to refer you to any relevant authorities in relation to this issue and make proper submissions about it.
So what point?
But to the question of whether the mayor's powers in section 152 affect either the extent to which a duty can arise, or the way that I would seek to analyse it, the remedy that the court should make if it's satisfied that there is a duty. But, my Lord, we say there's nothing in the Act which says if there is a breach of section 151, here is your remedy, see section 152, and there's clearly no express reference in the Act, and there's nothing we say implicit in the operation of the Act which says it should operate in that way. That the mayor does have discretionary powers, but nothing to indicate that the court's jurisdiction should be removed. And in my submission, our position would be, although we'd want to make more detailed submissions on it, that a person in the place of the claimant it is faced with the position of a decision which he considers to be unlawful. The question is, what is an adequate remedy for him in the context of that public law decision? The mayor has made a decision, the mayor of Tower Hamlets has made a decision. From the claimant's perspective, the only remedy in terms of remedying that unlawful decision, if it is found to be a breach of duty, is to bring a claim for judicial review. The mayor of London doesn't have the power to quash that decision. And insofar as it might be said, well, what the claimant should have done was write to the mayor and say, we're very concerned about this decision, please will you exercise your powers, we say that in no way would be an adequate remedy for the claimant, my client, and it's obviously his position, we say, that would need to be looked at in terms of the adequacy of that alternative remedy. So, my Lord, I think that's the position in a nutshell, that in terms of that particular issue.
Can I just ask one further question arising out of that? Is the remedy that you seek to quash the decision of the mayor, or is it a mandatory remedy?
That we seek two orders, but the primary remedy is the quashing of the decision to remove. We have also, as you'll have seen, sought a mandatory order requiring reconsultation. So that on any future decision. But I think in terms of the remedy that flows from the breach of statutory duty that we've pleaded, it is the quashing of the mayor's decision to remove the scheme.
Yeah, that's what prompted my question earlier, that in substance, what you're really complaining about is, in a sense, it's a negative duty, that you don't have the power to cut across, to run a coach and four through the mayor's transport strategy.
Well, I've attempted to answer that earlier. I say it's, as it were, the corollary of what we say about the breach of duty. Yeah. We do say that if the mayor, in our skeleton argument, if the mayor had wanted to do this, this is the way that the mayor should have gone about it, and that he is empowered to go about it by the statute. Yeah. And as you say, my lord, it may be a necessary inference from that submission that unless you exercise that power that's provided by the statute to prepare a revised live and submit it and so on, then you are acting out with your powers.
Exactly. Duties are usually enforced by mandatory orders. Unlawful exercise of power is usually remedied by quashing the unlawful decision. Ultimately, practically, it may get you the result that you're looking for, but I'm just trying to see conceptually how the law views these things.
Yes, my lord. Well, I hope that provides the answer to your question in that respect.
Thank you. Yes. Now, I'm conscious of the time, and we've interrupted you, so you just make your submissions as you wish to make them.
I'm grateful, my lord. I was intending to just briefly run through our case in a nutshell. I think you understand our case in a nutshell, and so I want to turn to the reasons why the judge found against us, and make sure that you have our submissions in that respect. If I can turn to the judgment, which is at tab 5, at paragraph 29, the judge identified a 6-stage analytical framework, and we are, as it were, happy to adopt that analytical framework and address you by reference to it. In the course of that analysis, at 29, the judge made a number of findings that were consistent with the claimant's case. There has been no respondent's notice, and so I don't propose to spend any time on those agreed findings, and I essentially invite the court to uphold the judge's findings for the reasons he gave in respect to stages 1, 2, 5 and 6 of his analysis. So by stage 1, the judge found that the section 151 implementation duty was not overridden by other statutory powers and duties on the part of the respondent. By stage 2, he found that section 151 imposed a clear and express statutory duty. Stage 5, he found that the lip had not been superseded, which was one of the arguments the respondent had pursued before the judge. Doesn't pursue here. And at stage 6, which is really relevant to all of the points that we have just been canvassing between ourselves, he found that the section 151 implementation duty was enforceable in judicial review proceedings.
Well, but does he actually make a positive decision to that effect? Because he starts in paragraph 31 by saying he has considerable concerns about stage 6. In the sentence bridging the pages, he says, I would not assume that stage 6 flows from stage 2. And then he says, I'm going to proceed on the basis that this court has jurisdiction. Now, what would you say to the proposition that what he's doing there is articulating an assumption? Because given that he finds against you on stages 3 and 4, he doesn't have to decide the issue on stage 6. So he's assuming it in your favour for the purpose of testing stages 3 and 4.
Well, my lord, that is not the way in which I read the decision. I say that the language has to, that the passage my lord read out needs to also be understood in the context of what follows. He says the discretionary bar of alternative remedy was not raised by the defendant for consideration. It would not be a jurisdictional answer.
Well, those are two different points. I'm sorry to dwell on this. Jurisdiction is jurisdiction. If a court lacks jurisdiction, it doesn't matter if parties haven't raised it. It can't do something it has no jurisdiction to do. The point about the discretionary bar of alternative remedies, as he says, it's not a jurisdictional answer. The point is that is where the court has jurisdiction, but chooses to exercise its discretion not to give a remedy because there's an adequate alternative remedy.
But as I read the judgment and the issue that the court was concerned about, it was whether there was an exclusive statutory remedy, that is to say whether section 152 provided a complete answer
No, I understand
to
that.
issues of breach. But
Mr. Barker, I don't want to take up time unnecessarily, but I have to say that, as my lord has observed, the judge appears in the first line of page 37 to be not deciding that the court has jurisdiction, but simply proceeding on the assumption that it does.
well, my lord, I'm prepared. I don't want to take up more time in submissions. Insofar as that's right, as I say, I think we would ask for more time or an opportunity to make submissions, but you have what I've said so far, and we've canvassed that issue between us.
Yes.
So I don't think there's anything more that I can add, whether or not, as it were, the judge assumed that or found that. With the greatest respect to him, obviously this court is now seized of the issue.
Yes.
All I would say is that it's no part of the respondent's case. There's no respondent's notice to that effect, and obviously no doubt the respondent is not going to take this point in his submissions having not put in a respondent's notice. The court needs to be satisfied of it, and insofar as the court has any concerns, as I say, I've set out what our position would be, but I'd ask for the opportunity to make further submissions accompanied by the appropriate authorities.
I understand.
I'm grateful, but the judge clearly rejected the claimant's case for three reasons. Firstly, the timetable in the LIP didn't provide the content for the scheme which could make it an enforceable statutory duty.
Yes.
Second, the scheme would require a TRO, traffic regulation order, to be implemented, a process which involved consultation and a decision to be taken. And thirdly, he said there was no ongoing duty to retain the scheme. So starting with the timetable point, at paragraph 33 of the judgment, the judge found that he was unable to find a prescribed timetable in the LIP, and that table 18 of the LIP, which we'll come and look at, didn't provide the content for the scheme which could make it a duty. As a preliminary point, my lord, this was not a point taken by the council at first instance. The judge suggested that stage 3 of the analysis was contested, but it was never a part of the council's case that the LIP did not contain a timetable, and I've given you the references to the respondent's pleadings at first instance at footnote 2 of my skeleton argument, and I will refer to the council's evidence on that point in due course. But by way of response, I just want to start by looking at the statutory provisions. We've already looked at section 145. Section 145(3)(a) requires a LIP to include a timetable for implementing the proposals in the plan, but the Act itself is not prescriptive as to the requirements for a timetable, but pursuant to section 144(2), the Mayor had issued guidance in relation to how LIP should be prepared, and it provides insight into why the timetable in the LIP was drafted in the way that it was. If I can ask my lords to turn to the supplementary bundle at tab 2, we have the LIP guidance, and I don't want to go through the LIP guidance line by line, but I would ask the court to pay close attention to it. It wasn't a document which received a great deal of attention in the High Court, principally because, as I said, the council wasn't contesting the point. But if I can ask you to turn within, I'm just going to give you what I say the key references given the time. 36 of the bundle, supplementary bundle 36, we see a section, part 1, at the top, sorry, yes, sorry, section 30, sorry, I was on the wrong page. Page 36, section 2, statutory elements, statutory context. We see the guidance referring to the statutory context provided by the 99 Act. And so I say we must take notice of the fact that this LIP guidance was cognizant of the legal duties that we've looked at in part 4 of the Act. And insofar as there's guidance within this document as to the need for a timetable for delivery of the LIP, this guidance is intended to ensure, among other things, that the timetable in the LIP is adequate within the meaning of the Act, so that it could in due course be approved by the Mayor pursuant to section 146. That is clearly the purpose, in part, of this guidance that's been provided by the Mayor. Then if we turn forward to page 41, we have chapter 2, Borough Transport Objectives. And we can see at 2.4 over the page on 42, the 9 outcomes of the Mayor's, of the strategy. That's the Mayor's Transport Strategy, the MTS. And we'll see those 9 outcomes reflected in the LIP, which is eventually approved. And the pages that follow in this chapter, there is then highly prescriptive guidance as to how the LIP should be produced, what it should contain, and so on. I'm not going to go through that in any detail, but we then have at 53, chapter 3, a specific chapter on the delivery plan. And as I said earlier, this chapter can only be sensibly be understood to provide guidance in relation to the statutory requirement for LIPs to include a timetable. And we see at 55, there's a heading, identifying potential interventions, and then we see a series of headings. Firstly, long-term interventions to 2041. So the MTS was envisaged to last until 2041, and so one of the categories of intervention, one of the timetables is to 2041. We then see a requirement for a 3-year indicative programme of investment, and there's some guidance on that. And then we then see on 57 an annual programme of schemes and initiatives. And just to complete the picture, there's then some guidance on monitoring that follows. In part 2 of the guidance, which begins on 67, there are then what are called toolkits, which are essentially templates for boroughs to use in the preparation of their LIPs. And then at part 3, we have some appendices with further detail. And in particular, at page 111, there is a summary of all the TfL mandatory requirements. And I would just flag up numbers 16 to 22 as being relevant to timetabling. So again, taken together, highly prescriptive guidance as to how a LIP should be prepared, including in relation to the timetable for the implementation of proposals, and of course boroughs with Can
you help me on this, because the wording in 16 repeats the wording that is, we saw earlier in the document. It's a list of potential schemes to 2041. So, is it your submission that everything in the list of potential schemes therefore has to be implemented? In which case, what's the import of the word potential?
Well, my lord, not an issue which arises on these facts, because we're concerned with the scheme that was included within the annual programme. So, again, not an issue which this court needs to determine for the purposes of my submissions. But
yes, you say that's irrelevant to the content of the statutory duty?
In the context of these facts, yes, because the timetable that the Mayor had to be satisfied as to its adequacy, he was satisfied as to its adequacy, contained the scheme that we are here concerned with. That scheme was identified in the annual programme, so the very first year of the timetable for the delivery. And so this was not a potential scheme to 2041. This was a scheme that was to be delivered in the very first year of the programme. So, yes, I say it's irrelevant to the issue that this court needs to decide, and the hypothetical scenario in which the court was required to determine whether there would be a breach of duty if a potential scheme that was identified in the LIP wasn't delivered by 2041 is not something that this court needs to concern itself with. But yes, the point is made, when this refers to a potential scheme, it's obviously, this is a scheme which the borough would propose to include within its LIP. It's then for the Mayor to decide whether the LIP should be approved. So in that sense, potential doesn't necessarily mean schemes that might or might not be delivered. These are schemes which are included as potential schemes for the Mayor to consider as part of the approval process. As I said, but the boroughs were statutorily required to have regard to this guidance in preparing their LIPs, and so it is no surprise in a real-world situation when we come to the council's LIP that it closely conforms to this guidance. And so, while the judge took a number of points about the timetable, against and said, well, this is not a timetable which could give rise to a statutory duty, we say that was an overly legalistic approach because there was specific guidance as to how a LIP should be prepared. And as we'll come on to see, the LIP was prepared in accordance with that guidance. Very conscious of time, my lords, but we have the LIP at 157. If I can just refer you by reference to the structure in the contents pages at 158, 159, we see a LIP which closely conforms to the guidance that was produced in terms of its structure. We see it at 4, the delivery plan, and we can see even in the headings, long-term interventions to 2041 at 4.6, 4.7 3-year indicative programme, and 4.10 annual programme of schemes and initiatives. Now, it is not in dispute, and it's recorded in the judgment, that the scheme that we're concerned about here was identified to deliver on MTS Outcome 1 and MTS Outcome 3, and we've seen those outcomes in the LIP guidance. And so then when we come to look at 4.7 in the delivery plan, which is on page 279 of the bundle, we see reference to the Love Your Neighbourhood scheme in table 17. And then at 4.8 we have supporting commentary for the 3-year and annual programme, and we see the supporting commentary incorporates both the 3-year and the 2019-20 annual programme. We see reference to the Love Your Neighbourhood scheme, table 18, and there's no dispute between us that the scheme we're concerned about was items 1, 2 and 4 in that table.
I thought it was table 18.
Sorry, yeah, that is table 18, sorry, on page 283. So say table 17 is generic headings, table 18 is a specific Love Your Neighbourhood scheme table. So 1, 2 and 4 are the specific schemes that we're concerned about. And some more detail is given about indicative timescales for delivery and so on. And the judge was concerned that they weren't, as it were, specific enough to give rise to an enforceable duty in terms of the timetable. But all of this was in the context of this being a scheme which was to be delivered in the very first year of the programme. That was the timetable for its delivery. And so when one judges the adequacy of the timetable, that is the context in which all of these more specific indications need to be understood. And we know that because if we look at 4.10, which is the annual programme, we see reference in the first box to Love Your Neighbourhood. The first priority area is being delivered in...
So which page are you on?
I'm on 297.
Right. Thank you. Yep.
The first priority area is being delivered in 2018 and 2019 are Bethnal Green. And we know if we look back at 282 that is the scheme that we're concerned with. So there is no, I say, no sensible doubt or dispute that in terms of the timetable for this scheme, the LIP was very clear that it was to be delivered in the first year of the programme. And in terms of the adequacy of that timetable for the purpose of the duty, and more to the point, it's for the mayor, pursuant to section 146, to assess whether the timetable for implementing the proposals was adequate. And in this case, the mayor was satisfied. We have his approval at 308 of the bundle. And you see he approves these LIPs as a bundle of LIPs. We see that at 308. The Tower Hamlets specific approval is at 372. And I'd ask the court to consider this, but at the bottom of 373, we see specific reference to the requirements for the delivery of the schemes, reference to the requirements for a timetable, and explicit approval by the mayor of the timetable. And we say, but by finding that the timetable did not provide the basis for the duty to arise in this case, the judge has effectively gone behind the mayor's decision that the timetable was adequate for the purpose of implementing the MTS, and so the judge erred in going behind the Mayor's finding. And the London Mayor's decision was to approve the LIP wasn't challenged, and it's just not appropriate, we say, to re-examine the adequacy of the timetable many years after the event, not least on the facts of this case. I then want to just briefly look at 151, which is the implementation duty. That's at tab 2 of the authorities bundle. The implementation duty, as we can see from 151(1)(a), is to implement the proposals in the LIP in accordance with the timetable included in the LIP. So the substance of the duty that we're concerned about is not concerned with the adequacy of the timetable. The judge's findings effectively ignore the fact that the implementation duty is tied to the timetable in the LIP, whatever that timetable may be. And so adequacy of that timetable simply isn't an issue when one is looking at implementation. The adequacy of the timetable is only an issue at the prior stage of the analysis. That's to say, whether the LIP should be approved at 146. Third point on this, any concerns about the timetable in the LIP are wholly irrelevant on the facts of this case because the scheme was implemented in accordance with the approved timetable. And I've referred to the Council's evidence. If I can just give you 2 references and then take you to a third. Supplementary bundle 688 and supplementary bundle 753 to 4.
Sorry, can I just have the page numbers again?
So 688 and 753 and 4. But if I can ask you please to turn to 758, where we are here within a witness statement produced on, and this is tab 18, a witness statement produced by the Corporate Director of Communities at the respondent. Page 758, as I have said, paragraph 26, the Council's own evidence to the court was that the Council's LIP set out a 3-year programme which, in accordance with section 145(3) of the Act, included a list of proposals, including the scheme.
I must be on the wrong page, I do apologise.
Sorry.
I thought you said page 758?
Supplementary bundle 758, tab 19.
Yeah.
Right.
I'm at
Tab
paragraph
19.
26.
Okay, thank you.
That's next paragraph.
And then the witness goes on to say, as required by section 151(1), the Council then implemented various proposals, including the scheme, in accordance with the timetable included. So we just say the court didn't need to concern itself with the adequacy of the timetable and the facts of this case given the Council's position. Whether there might have been a breach of duty on other hypothetical facts, which are not the facts of this case, is completely irrelevant, we say, to whether there was a breach of duty here. And we say that the judge essentially elevated hypothetical factual issues that could arise in other cases to the status of a legal bar preventing the duty from arising in all cases, even though those hypothetical concerns have no relevance to the facts of this case. We just say that was wrong as a matter of approach. And so we've taken everything together. We say it was wrong for the judge to find that the duty wasn't engaged on the basis that the LIP didn't contain a timetable, given that the timetable had been approved by the Mayor of London without challenge. The duty to implement was referable to that timetable, and the scheme was then implemented in accordance with that timetable. That's reason one. I'm crack on as fast as I possibly can. Yeah. Second point was a contingency point. So para 34 of the judgment, the judge found that the fact that the projects in table 18 of the approved LIP were contingent on the making of individual traffic orders, which themselves required public consultation, meant that there could not have been a statutory duty to implement those schemes, because that would have meant the Council would have fettered its discretion in respect of those later statutory processes. We say the judge was obviously wrong on that. 2 points. First, again, preliminary, this was not a point taken by the Council at first instance. It was a point entirely of the judge's own making. Secondly, it was not a point which arose on the facts of this case, again, because the scheme in question was implemented by reference to traffic orders supported by public consultation, and again, whether on the facts of another case a breach of duty might arise when the council decided following consultation not to make the relevant TRO, not to implement the scheme, is irrelevant to the facts of this case. Again, we say the judge elevated hypothetical factual concerns that might arise on other cases and said, well, that's a reason why the duty can't arise at all, even though on the facts of this case it was completely irrelevant. But finally, in terms of the substance, the fact that other schemes in the LIP, that the schemes in the LIP were contingent on the fulfilment of other statutory processes, doesn't, we say, undermine the existence of the Section 151 duty. Firstly, many schemes which are included within a LIP are contingent on the making of traffic orders. That is the way transport planning and delivery works. One needs to often make traffic regulation orders. The Part 4 of the Act was clearly developed cognizant of that fact, and it would simply make the LIP duties and the operation of the Act unworkable if the duty didn't bite on those measures which were required to be implemented by way of TROs. But what is more, in this case, the LIP itself identified risks to the delivery of schemes. And if I can ask you to turn to page 136 and 7 of the supplementary bundle.
We have got to the end of the time allotted for the opening of the appeal, but what we'll do, if necessary, we may have to reduce some of the time for your reply.
I think that's sensible. I'm grateful for a little bit more time just to finish my submissions, and I'll cut my clock accordingly.
How much longer do you need?
I think 5 or 10 minutes, probably.
Well,
but I'll have to cut.
Try and make it 5.
I will. So it's 136 and 7 of the supplementary bundle.
Yeah. We're
in the council's LIP, and we can see at 137 sorry, no, I'm afraid there's not a dodgy reference. I'm just going to find the relevant
don't worry.
Reference. Sorry, it's page supplementary bundle 296. It's internal page 137, I'm sorry.
296.
296. We're here in section 4.9, which is risks to the delivery of the 3-year programme and annual programme. And one of the specific risks identified, third row of 296, individual projects are not supported by the public at the consultation stage. So the LIP expressly envisaged the possibility and indicated that what the mitigation would be to undertake appropriate consultation or even to redesign the project to resolve objections.
So what about the first item, change in policy or political direction?
Well,
Does that not include election of a new mayor on a different mandate?
Indeed, but that is expressly identified as a risk to the delivery of the programme, and mitigation is identified as being ensure that members are frequently engaged in a variety of schemes through different policy areas. But I say the reference in that being a risk to the delivery of the programme is cognizant of the fact that there is a duty to deliver the schemes in this LIP, and that change in political direction is identified to be a risk to that delivery.
But the last column is impact if not mitigated, and impact is non-progression.
Yeah. But again,
you say they're obliged to progress regardless.
Yeah, the risk is non-progression, but it doesn't say that all of this is produced in obvious cognizance of the fact that by not progressing, you'll be placing yourself in breach of the statutory duty to implement. But that is expressly identified as the risk. And that's precisely why it's expressly identified as the risk. That's the whole purpose of this table, which is to identify risks to the delivery of schemes which there is a statutory duty to implement. And again, I say that what this table is doing is seeking to ensure that the LIP duty can be discharged so far as possible, or identifying the potential consequences of if it's not, where schemes are not supported by the public or need to be redesigned. And as I've said, in another case where public consultation threw up an issue which called into question the delivery of a scheme within the LIP, that there are a variety of ways to remedy that. Redesign the scheme or ultimately submit a revised LIP. The statutory framework envisages ways in which those risks can be overcome. The final point taken by the judge against us was that implementation did not necessarily encompass retention. And we say that implementation is clearly not referable to a single act at a moment in time, whether that's the making of a traffic order, the construction of a cycle path, or whatever the measure might be, because the scheme is not implemented and the duty to implement the LIP fulfilled when that particular measure is installed. Implementation of the LIP requires having the schemes within it in place as envisaged by the strategy. Because at the end of the day, when one traces the path all the way back to the Mayor's transport strategy, the headlines are reference to objectives, strategies. They're not referable to particular concrete on the ground. They're referable to things that need to be achieved by a certain point in time. And so implementation of the physical infrastructure necessarily encompasses retention, because otherwise those scheme objectives won't be delivered. There's no separate duty to retain because it's all encompassed within the requirement to implement. The judge said, well, that needed to be spelt out in the LIP if it was to exist. And we say that's obviously wrong. There was no need for it to be spelt out because it is obvious to any informed reader of the LIP who will have a knowledge of transport planning in London, will have a knowledge of the MTS, that the function of the LIP is to implement the MTS. And, my lords, you only have extracts of the MTS, but it is clear from that document read as a whole that the MTS outcomes to which a scheme is explicitly identified to strongly contribute are objectives to be delivered by 2041, so the lifetime of the MTS.
Do you submit that when the legislation is read fairly and as a whole, what it amounts to is that the duty on the borough is to have in place things which are consistent with the Mayor of London's transport strategy. So implement means not just implement on day one, or even actually in year 9. Because I know there's been a lot of debate in the court below about whether you could tear it all up the next day. I'm not sure, speaking for myself, that that's really a helpful scenario. But what might be a perfectly realistic scenario is that in year 9, it's decided by the borough that they think the current arrangements are not satisfactory for their needs. I think your fundamental submission is that's fine, but the legislation creates a mechanism for changing things. And what you can't, to implement doesn't mean that you did once implement it. It means you have to have it in place, and at all continuing times, it has to be consistent.
Yes.
With the Mayor of London's strategy. Is that what it amounts to?
Yes. Indeed. And unless you go down the route of submitting a revised LIP and have that approved by the Mayor, which it is feasible that a local authority could demonstrate that they could contribute to meeting the transport strategy and the outcomes by removing a particular scheme and doing something else or doing it in a different way. But all of that is subject to the approval of the Mayor because the LIP is intended to ensure the delivery of the Mayor's transport strategy. I'd also just add one thing, which is the section 151 duty is specific to the proposals in the LIP. So it drills down to the level of the particular proposals that are identified within the LIP, and it is those proposals which are required to be implemented. It's not simply implement the strategy, it's implement the specific proposals in the LIP. So once a proposal is in the LIP, the duty is to implement and retain that proposal.
Well, we think we understand your submissions.
I'm grateful, my lord. Ground 2 is set out in my skeleton argument. I would propose in the time simply to adopt what I've said in my skeleton argument. And
we have carefully read that, and we've carefully read what's said in opposition to it. You don't have to elaborate on it.
I will adopt that as my oral submissions, and
very good.
those are my submissions.
That's very helpful. May I check if my lords have any questions? Thank you very much. Yes, Ms. Kilroy.
My Lord, I appear on behalf of TfL as the interested party, supporting the appeal on ground 1. If I may respectfully say so, my Lord, the question that you asked at the start of my learned friend Mr. Parker's submissions encapsulates what has gone wrong with the High Court judgment in this case, which is that the judge answered a different question to the one that was before him. He answered the question, could the Section 151 duty be enforced if it was not implemented within the timetable set out in the LIP? Whereas the real question that was before him was, could the respondent remove a scheme implemented under a LIP without following the revision procedure? And you can see that that was the question before him from the interested parties' skeleton argument in the High Court, which is in the core bundle at page 150, paragraph 3.
Can I just get... Sorry, which paragraph?
It's paragraph 3
Thank you.
is the summary of the
I beg your pardon, could you
argument.
give me the page
So it's
again?
page 150, tab 11.
Thank you.
And you'll see the position, the statutory position at paragraph 2. If I could ask you to read paragraphs 2 and 3.
Yes.
So it's any decision taken to remove the scheme before that proper procedure set out in the statute has been gone through is unlawful. That was the argument that was made. And you can see the argument expanded on at paragraphs 33 to 40 of this skeleton argument, pages 157 to 158. And again, you'll see that the punchline for those arguments based on the statutory scheme is at paragraph 39. Until all these statutory obligations have been complied with, no lawful decision to remove the scheme can be taken by the defendant. And the reason why the argument was put in that way, and it is, as my learned friend Mr. Parker has explained, timetable was simply not an issue in this case. The scheme had been implemented, it had been installed.
Suppose it hadn't been.
Yes.
Let's just test the legal point by reference to a hypothetical scenario where either there isn't a timetable or there is a timetable but it hasn't been complied with. But the London Borough says, well, we don't care what the LIP says. We're not interested in that because we've come up with a completely different proposal. And so we're going to implement that. I think your submission would be exactly the same. That a decision to have, in effect, a completely different LIP can't be done except through the statutory procedure for revising an LIP. So is that right? Would your submission be exactly the
Yes,
same?
it's unlawful not to do anything that is in conflict either with the original approved LIP or with the Mayor's transport strategy because of the whole structure of the scheme without following the procedures in Part 4.
And either that's a good submission or it's a bad submission. I'm not saying which it is because I haven't heard the other side yet. But that's what the case is really about, you say.
Yes.
And everything else, like timetables and so on, you say it's a distraction. They may or may not have been complied with, but it doesn't matter. You
Well,
say.
it's certainly a distraction on this case because the timetable was complied
Well,
with.
I understand that, but that's why I was testing
And-
it. But I was testing the point
Yes.
of principle. But I think I have your answer. Thank you.
Yes. So what the claimant was seeking, as my learned friend Mr. Parker explained, was an order quashing the decision, not an order to enforce.
Shall we just have a look at what, because we haven't actually been shown
Yes.
the claim form and the way in which it was put originally. It may be helpful just to remind ourselves of that.
So the claim form is at tab 17.
Yes. And how is the decision described? Yeah, it's page 227.
Yes, the decision to approve the removal of a low traffic neighbourhood scheme.
Yeah.
And
And the
the
remedies.
remedies are at 263,
263.
263 of the grounds of claim,
Usually it's in the claim form.
maybe in the claim form as well.
I know the practice has developed of having.
Refer to 233
Yeah.
refers to the statement of grounds.
Oh, I
Yes.
see. All right. So yes, I was going to say the practice has developed of having what is effectively a skeleton argument in what's called a statement of facts and grounds. I'm not saying that by way of criticism because everyone does it. And the relief sought is at
263.
263.
And you'll see a quashing order in respect of the mayor's decision to direct the removal of
Yes.
this.
Yeah. So the essential point, if I got this right, that no one was actually asking for a mandatory order to implement the current LIP.
No,
The focus of attention was you've decided basically to scrap the current LIP without going through the appropriate statutory process.
yes. That was the argument. That was the argument below. But it then developed this issue of timetable and whether there was sufficient precision in the timetable was raised by the judge. And it is important that it wasn't raised at any point by the defendant, as it was then, the respondent, because the respondent's argument then, and you'll see this from paragraph 45 of the judgment, was that it evolved as the judge explained, but that they were either going to seek a revision of the LIP, that was one of the arguments, or there had been an approval of the decision to remove. That was another of the arguments. And again, I'm just going to, so that was the way the argument proceeded its tab. I say it's 45, but I think it's actually not.
No, I don't.
It was 30, paragraph 30.
30. Yes.
You'll see in the pleaded defence, a point was made suggesting the decision was or would be contingent on a subsequent application for revision. So that was acknowledging that a revision was required. That argument was then abandoned. Then in the skeleton argument, so that was the pleaded argument, and you can see that from the respondent's pleadings.
Yep.
In the skeleton argument, prior to the hearing, there was an argument that in fact the mayor had approved a change in the scheme.
Sorry, which
But
mayor?
that-
Which,
you
which,
can see that
which
as to
mayor?
stage
Sorry,
5.
which mayor had approved?
The mayor, as in the TfL, the mayor of London. The argument was made that there had been an approval by TfL of a strategic plan, year 1 annual delivery as having superseded the LIP chapter 4.
Right.
That was a mistake, sort of a plain mistake of fact,
Okay.
which was then abandoned at the hearing.
Right.
So at no point was it ever argued, either in the pleadings or in the skeleton argument, or indeed at the hearing, that there was an issue with the timetable. This was a point raised by the judge
Was it raised at the hearing?
at the hearing.
Yeah. So no one's complaining that they didn't have fair notice of it.
No one is
It's
complaining
just they're
that they
saying
didn't have
that-
fair notice, but it's just by way of explanation as to why, in fact, the focus of the judgment shifted
Yeah.
away from what had always been argued by the parties onto something that, with respect to the learned judge, was really a red herring on this case.
Ms. Kilroy, can I ask you this? Was the burden of the defendant's argument below, respondent now, that they had complied with the law because implement means implement,
Yes.
not retention later on?
That was what became the focus of the respondent's argument
Right.
at the hearing, which is the third of the judge's reasons.
Yes.
And what I was proposing to do, particularly given the time, and that you've heard from my learned friend on the other arguments, in my respectful submission for the reasons I've explained, the timetable, the consultation argument are red herrings here. The only real issue is, did the judge get it right in rejecting this argument that I've put forward, which is that it wasn't a breach of, it wasn't necessary to seek a revision because they had already implemented it and that meant they could remove it. Was he right to conclude that? And in my respectful submission, if he wasn't, then that is the end of the matter as far as this appeal is concerned, or this ground of appeal is concerned. So what I was going to do is turn to that argument now.
Yes, please.
So the the question of whether you can, once you have implemented or installed a scheme, this scheme, just remove it. And as my learned friend has already suggested, this is not a question of the next day. We accept here that the scheme was in fact in place for some time. But at any point, without revision, is it possible to remove the scheme? Is implementation an ongoing duty or a one-off event? And in my respectful submission on behalf of TfL, it is clear that it must be an ongoing duty. That is both because of the statutory scheme, but also because of the content of the Mayor's transport strategy and the LIP. You've looked at the provisions, and I won't go back to them because of time, but they make clear that what is required is a cohesive transport strategy for the duration of the period identified, which in that case was until, in this case is until 2041. A cohesive and integrated transport strategy across London. A transport strategy is necessarily an ongoing commitment. It cannot be a one-off project. It is dependent upon the measures that contribute towards it achieving its goal remaining in place.
Does it amount to this, Ms. Kilroy, that the Mayor of London has gone through an elaborate statutory process for devising a transport strategy for Greater London until 2041?
Yes.
And there are many boroughs within London who have a duty to implement LIPs consistent with the Mayor of London strategy. Have I got that right so
Yes.
far? Right. So if the respondent's argument and what the judge held is correct, what could happen is that over the coming years and decades, one London borough here will say, well, actually, we now think a better LIP would be one which is inconsistent with the Mayor of London strategy. So that'll happen in year 5. Another one over there says in year 9, we've got a better strategy as well, or a better policy, which is inconsistent with the Mayor of London strategy, so we'll do that. And eventually, your submission is it's going to cause inconsistencies with the overall strategy for Greater London, and that can't be what Parliament envisaged.
My Lord, precisely. A fractured transport system with oscillating priorities according to separate political objectives of each borough is not what Parliament had in mind. It's precisely anticipating the likelihood of those kind of political pressures in London, it's precisely with that knowledge in mind that Parliament came up with these powers, this scheme and these duties on boroughs to follow the mayor's direction and on the mayor to enforce it.
And presumably, because life does change, political elections happen, there can be a change of political direction. We've seen that phrase in one of the documents. There could be a change of political direction at the Mayor of London level, presumably.
Yes.
Does the Act accommodate that possibility? But presumably that would be that the Mayor of London would have to revise their strategy for the whole of Greater London. Is that how it would work?
Precisely, my lord. The Act contemplates a number of ways in which the transport strategy and the LIPs can be revised and changed, but all with a view to it being done in a cohesive fashion and a democratic fashion with consultation. So without going through each of and asking you to turn it up, you will see when you go through sections 141, sections 142, and you can see, for example, at 142.3, that the mayor can revise the transport strategy. He then has to consult people. You heard already that the Secretary of State sits at the top and can issue directions to the mayor. But again, it's all done in this centralised way so that there is cohesion and consistency. And as far as the plan, the LIP, in other words, the local level, if LIPs need to be revised, there is the possibility of revision at 148. So it's again giving the possibility of local authorities with new political priorities seeking to prepare revisions, but they must do so consistently with the transport strategy. They always have to have an eye on that. Once they do that, they consult and so on.
And if they thought, or a group of them thought, actually, Mayor of London, this is a very bad strategy. It was written a long time ago, and we're now in the year 2035, and I know it says 2041, but it's a really bad strategy now. Does the Act contemplate that the way they should proceed is that they talk to the Mayor of London and they try to agree compromise through discussion? Is that how it works?
Well, it's not put in precisely those terms, but the revision procedure permits that to occur because the mayor is one of the consultees. And of course, there is also the possibility of getting together and seeking direction from the Secretary of State to the mayor.
Oh, I see. So could the Secretary of State at some future date direct the Mayor of London to have a different transport strategy?
He may. That's what Section 143, where the Secretary of State considers that the transport strategy is inconsistent with national policies relating to transport and that the inconsistency is detrimental to any area outside Greater London, he may direct the Mayor to make such revisions of transport strategy in order to remove the inconsistency.
Yeah, well, I see that, but that's not as general a power as might at first sight be.
No, it isn't.
If it doesn't affect national strategy or areas outside Greater London, then the power wouldn't arise.
So Parliament, but that only means that Parliament has foreseen that the Mayor has even stronger powers, and that the Mayor should have full control over what occurs in Greater London as long as it doesn't affect what is going on outside. But Section 148(1), a London Borough Council may at any time prepare such revisions as it considers appropriate to the council's local implementation plan. That is the way in which the London Borough Councils can seek revisions. But it is Parliament's scheme that they must always have regard to the guidance in the transport strategy in any function. So you see that at section 144.2, at 144.3, in any of their functions, not just in their LIP function. So it is a muscular set of powers which gives ultimate control to the mayor. And that is what Parliament has envisaged.
And if the mayor revises his or her strategy, then that has to be followed through by the local borough as well. I think that's 148.2, is it?
That's right.
So there's that hierarchy again.
At every stage.
That may be something which is not very popular with the local borough, but it seems to be saying that the mayor trumps the local borough.
The inexorable conclusion from these provisions is that at every stage the mayor trumps the local borough.
Yeah, of course, one of the things that's happened in local government law in the last 20 years or so, 30 years, I think, is that some parts of the country have elected mayors, but not all parts, directly elected mayors.
Yes.
Is this right? Not all the London boroughs have directly elected mayors. I'm not aware of that.
Not all of them, no.
So you may not be able to help us with this, but I'm just interested. When did the possibility of having a directly elected mayor for Tower Hamlets first emerge?
I would have to take instructions on that.
Don't worry if you don't know. But anyway, the point is that the Greater London Authority Act 1999, which is what we're construing, it applies to all London boroughs,
Yes.
irrespective of whether they themselves have a directly elected mayor.
Yes.
They may or may not do. Parliament has chosen, since 1999, to allow for that possibility, at least in this borough. But the fact that there is a directly elected mayor in a London borough, you submit, doesn't mean that the structure and interpretation of the Act has changed.
It doesn't dilute the powers that Parliament has conferred on the Mayor of London. And you can see why, for the reasons that my Lord outlined, that would be the case. Because when we say that the Mayor trumps the local boroughs, what in fact trumps the interests of local boroughs is having an integrated transport system in a capital city that requires transport to work for every citizen across boundaries.
I see that point from respect to the statute, but I mean, how far can you take that? Because we're concerned here with a local traffic scheme. To what extent does that have London-wide implications? I mean, even, I suppose it could do, but I mean, these are Liverpool neighbourhoods, aren't they? That's what it's all about.
It's about cycling. People cycle, for example, from one borough to another borough. If the vision that you see, and we haven't had time to go through it, but if you look at the transport strategy and the outcomes of healthy streets, Ms. Clark's witness statement at tab 17 provides it, and you've looked at those, but what you'll see is that the idea is that across London as a whole, by 2041, 80% of journeys will be taken either by on foot, cycling, or with public transport. That is the goal. Now, that is something that will not work if people are unable to do it in one borough over another. It has to be integrated in order to function properly. People will have to leave their bicycles at the edge of Camden when they go into Westminster.
Sorry.
No, sorry.
I was going to say, Ms. Kilroy, I think we understand the way you put your arguments. I don't want to curtail your submissions.
Well, I'm going to have to stop in order to keep into time, but I just want to give the punchline on the removal argument, because, of course, the Mayor and TfL says that it cannot be the case, set against the backdrop of the scheme as a whole, of the LIP, looking at the LIP guidance and the Mayor's transport strategy, that you could put in the physical installation for a scheme whose goal it is to reduce pollution, to reduce the use of cars, to enable people to use their bicycles and walk around, and say, I've implemented it, if in fact you're going to remove it after 2 years. The whole structure of the transport strategy is forward-looking. It's about reducing over time the reliance on cars and improving the environment, reducing road deaths, creating healthy streets. That is something that has to be done over time. So it is inherent in the proposal that is implemented. So implementation here is of the proposal. The proposal is for a low-traffic neighbourhood. That is something that is inherently ongoing and continuous. And the conclusion, any other conclusion, with respect to the learned judge, is obviously doesn't make any sense. It must be and is an ongoing duty. And so his conclusion on that is wrong. He also gave some footnotes as to why he was fortified in reaching those conclusions. He said that although in theory you could remove the scheme the next day, you would be subject to public law rationality duties. Well, in my respectful submission, that is not enough against the backdrop of this scheme. It is clear that the mayor is given powers, and you haven't looked at it, but I do ask you to look at it. Section 152, the enforcement duty on the mayor is very broad and very wide. And the reason for that is that the mayor is to have the possibility, even if he doesn't exercise the discretion to use it, to be able to enforce these provisions. The mayor should not be required to go to court to establish that a public authority has acted irrationally in the removal of a scheme.
Yeah, would it come down to this? The Mayor of London would say, I'm not interested in the public law question of whether what you've done is irrational. What I am interested in is that you've done something which is inconsistent with my strategy.
That's right, and that's what Section 152 says. It gives and you will see from Section 152, which is also relevant to the timetable point, my lord, that when the mayor looks at the question of whether there has been compliance, he is looking not just at whether the duty has been implemented or the LIP has been implemented, but whether it's likely to be implemented. And he's looking not just at whether it's likely to be implemented at all, but whether it's likely to be implemented satisfactorily. So those are the criteria that the mayor is looking at. And it is for him to consider. So in other words, it's a discretionary decision and a judgment on his part. So the powers of enforcement are extremely wide for the mayor, and they must remain so. That is what the Parliament has intended.
I understand that, but where does that go to? Because the more you stress the breadth of the mayor's power under Section 152, the more one wonders why the mayor doesn't use that power, which is not your case before us. Your case before us is you don't need to because the Tower of Hamlets decision is unlawful.
Well, my case before you is that the decision is unlawful. The claimant has come before you and argued and asked for a remedy from you, and the mayor considers the decision that is unlawful, so it supports the claimant to that extent. It doesn't mean that the mayor needs the breadth of the discretion that is endowed, that the mayor is endowed with, doesn't mean it has to, that he will exercise it. What I'm asking this court to do today is not to circumscribe and to ensure that the judge's decision does not circumscribe those powers when the mayor decides to, in his discretion, to exercise them. And as currently set out in the judgment, there is a risk that that will happen because the judge has said that the mayor must do a range of things, including set out a precise timetable, which is not in fact what the statute says at all, before the duties in Section 151 become enforceable. And with respect to him, he's wrong about that in my
Does it amount to this, that if the judge's judgment stands, and leave aside all the timetable points and so on, but focus on his third reason.
Yes.
If that stands, that you can implement and you don't then need to retain something which is consistent with the Mayor of London strategy, then the Mayor of London won't be able to use the Section 152 powers to bring any complaint about the London Borough, because the law says that they've complied. What they've done is perfectly consistent with his strategy.
There is a risk. I don't want to give up the possibility of argument around that, but there is certainly a risk that may occur, because the judge has, in parts of his judgment, suggested that that the Mayor should have made it explicit.
Well, indeed, I thought this was why I asked my question, because you were emphasising the breadth of the 152 power.
Yes.
And the broader that power is, the less risk of the judge's decision undermining it.
I accept that those are the broad parameters of his ability to intervene. But what the judge has done is suggest that the Section 151 power does not mean what it says. And if the judge's conclusion stands on timetable, but also on what implement means, then there is a problem with exercising the Section 152 power.
Yeah, I mean, there might. I don't want to set hairs running, but there might be a public law argument several years down the road, which is that it doesn't matter what you've included in the LIP. If you don't have the power to include it, you don't have the power to include it. That's
Yes.
at least that's
Yes.
a risk that you say could arise.
Yes.
Anyway, I think I'm conscious of the time.
Yes.
Necessarily, you had to go over your allotted time because you were delayed in beginning. But is there anything else that you need to add?
I'm not going to add anything more except to ask you to, and to adopt, as my learned friend Mr. Wolfe did formally, my skeleton argument.
Of course.
Because obviously I've not been able to address everything.
Well, we have
in the
read it
detail.
very closely. Thank you. May I check if my lords have any other questions? Thank you very much. Yes, Michelle.
Thank you, my lord.
And
My lord-
just to be clear, if I may, because you've had to start about 10 minutes later than you were allotted, your finishing time now will be 3:50 this afternoon.
Thank you, my lord. And you anticipate stopping at 1 o'clock?
Yes.
Yes. Thank you, my lord. My lord, it won't surprise your lordships to learn that I maintain that the learned judge below got it right, and we rely on his findings there. Dealing with the points made, I'll start with the lip issue and the arguments made. My lords, the difficulty with the appellant and the interested parties argument is that none of it is grounded in law. None of it. It is not grounded in any of the statutory provisions. It doesn't take into account other statutory provisions that are relevant. Neither of them have mentioned the Traffic Management Act at all, and they haven't mentioned how the TRO process works. So they have put forward a proposal and thoughts and meanings as they would wish the world to be, but regrettably for them, the law doesn't support that. And I'll make those points good just by dealing with the statutory process. The first point to note is that there is a Traffic Management Act that is in the authorities bundle. My lord, I hope you were sent through the correct section 18. I think it may have section 14 in there. 16, sorry, I have got hard
16,
copies.
yes. Yes, it would help if, because we have hard copies of everything else,
Yes.
that would be helpful.
Thank you very much. So that should go behind tab 3.
Right.
In fact, section 14 is just in error. I don't know why that's in there.
Right. Thanks very much.
So, my lords, the Traffic Management Act 2004 then contains at section 16 the network management duty. This applies to the London Borough of Tower Hamlets.
Right.
It cannot just be ignored. It is part and parcel of the statutory matrix.
Yeah.
Section 16 sets out what the network management duty is, and that is in relation to the local traffic authority, which is in this case Tower Hamlets. They have to manage their road networks with a view to achieving, so far as may be reasonably practical, having regard to their other obligations, policies and objectives, the following objectives, and then they're set out what they have to do, which is expeditious movement of traffic on the authority's road network and facilitating the expeditious movement of traffic on the networks, for which another authority may be a traffic authority. And, my Lord, subsection 2 makes it clear what action they can take, and that is set out at A and B. And it then says, this may involve the exercise of any power to regulate or coordinate the uses made of any road or part of a road in the road network, whether or not power was conferred on them in their capacity as a traffic authority. Now, this network management duty involves having regard to a whole host of issues, including the movement of people with disabilities, waste authorities, movements, ambulances, a whole range of users of the road have to be taken into account here. And that is the network management duty that governs Tower Hamlets. This has to be understood. Along with that is section 17, which are the arrangements for network management. That's just over the page. And that sets out that the network management authority, which in this case is Tower Hamlets, shall make such arrangements as they consider appropriate for planning and carrying out the action to be taken in performing the network management duty. And then it sets out there, you can see what needs to happen. So, well, the first point is that this Act prevails as well. It has to be part of the matrix. This is not...
When you say prevails,
yes.
Do you mean that this, in a hierarchy, this prevails over the 1999 Act?
No, my Lord, I don't say it prevails over because that's not what Mr Justice Fordham found. I did maintain that it did, but I'm happy to proceed on the basis of Mr Justice Fordham's... it doesn't matter for the purposes of the argument. So, my Lord, but what it clearly does do is it is a statutory duty on Tower Hamlets. My Lord, in terms of section 17 then, that's the arrangements for the network management, and it sets out how that has to happen. Now, that's the first point that can't be ignored. And as I say, neither of my opponents have even referred to this duty.
Well, can you enlighten us as to the relevance of
Yes.
the duty in your submission? Because, I mean, it establishes that if it were not for Section 151 of the Greater London Act, then the Mayor of Tower Hamlets would have the power to do what he's done. But that's not, on the face of it, an answer to the argument based on 151, is it?
Yeah, well, my Lord, precisely, it is, because 151 doesn't override the Traffic Management Act either. All that it does is it is part of the achievement of the expeditious movement of traffic. And this is why I'd maintained earlier, before Mr Justice Fordham, that it did override, in a sense. It was a parent act. Because if you look at 16.1, it says it's the duty of the local traffic authority to manage their road network with a view to achieving so far as may be reasonably practical, having regard to their other obligations, policies and objectives. And I would say that the Act, the Mayor's Act, the Greater London Authority Act, does contain other objectives and duties. So that's something...
So you accept? Yep.
Yeah. So it has to be done in the light of that. But that doesn't mean that the Greater London Act supersedes or overrides or takes precedence. There's nothing in that Act that says it does. It doesn't say that the Traffic Management Act is overridden or the network management duty is subservient to it. There's another aspect to this as well, and that is the Council's public sector equality duties. Those also have to be taken into account, and they may mean that some of these schemes or any of these schemes give rise to impacts and affect protected characteristics. Therefore, it would be completely wrong to say that the Mayor's 1999 Act somehow prevents anything being changed once it has been implemented, because it is necessary at times for the direction to change. Now, this is something that's recognised in the officer's report. So if I could just ask your Lordships to go to the officer's report. And you can see this quite pithily at the, it's SB 491, paragraph 711.
So page 491.
Yes, my Lord, SB 491. fact, it's probably worth just going to the page before, which sets out comments of legal services. So 490.
Which paragraph?
So 490, and it's paragraphs, paragraph in particular, 7.9,
Yes.
which is the act under which these traffic orders are made, the ones that Tower Hamlets is wanting to make. All it's done at the moment is resolve to make them.
Nobody, incidentally, has shown us the 1984 Act.
I'm going to go to that.
Very good.
Actually, that's a quite.
Thank you.
My lord, then over the page, 710, it sets out what the statutory duties are to make these orders, because that's what this is all about. It's the removal of the LTN, or the lovable streets, or livable streets, whatever one wants to call them, has to happen through the making of traffic regulation orders. That happens underneath the Road Traffic Regulation Act. That's why it's so important to look at the entire matrix of these acts and not just pick out one in isolation. So even if, and it's very important to understand as well, even if the LIP schemes are implemented, they have to be done through this act. So it's not that the 1999 Act in and of itself says, you've got a LIP, these are the schemes, in they go. That's not how it works. There have to be TROs made under this 1984 Act. Now, the importance of that is that at 710 it tells you what has to be taken into account to make those TROs. And you've got the bullets there. So those two are not, there's 2 minutes, are we at 1 o'clock?
Yeah, that's slow, but
That's
you
it.
carry on.
So, my lord, the important point here is that at 7.10, when you are making the TROs, in other words, when you're implementing those schemes in the LIP, the ones that we're talking about, you have to make them under Section 122 of the Traffic Regulation Act. And in doing so, so before you can implement them, you have to have regard to all of these matters. So the mayor, with his strategy, doesn't override that statutory context and requirement. You still have to make them through this process. And that process, which I'll pick up after lunch, involves a whole consultation process for which the outcome is not decided. It could be no. The consultation requirements could say no. And then we'll come back to the point about whether implementation can ever mean permanently in perpetuity.
Very good, thank you very much. Oh, yes.
Sorry. Just on the, it may be a question you may be able to help with over the break, but on section 18 of the Act that you just showed us, sorry, section 16, so is traffic defined anywhere?
My lord, I don't believe it is, but I will check over the lunch break.
Does it include pedestrians? Yes. Does it include bicycles?
I believe it does, yes. It's all forms of traffic.
Right, that would be very helpful if you could check that. Thank you. Right, we look forward to hearing you again at 2 o'clock.
Thank you.
For rise table.